Good morning and welcome to the Maryland Public Service Commission's administrative meeting for January 13th, 2021. We'll begin today by approval of the minutes for our last meeting on January 7th, 2021, beginning with Commissioner Herman.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Mr. Chairman, I was not present due to technical difficulties. I will abstain from this vote.
Thank you. And Commissioner Richard.
Aye.
I vote aye. The meeting minutes are approved. Good morning, Mr. Secretary.
Morning, Mr. Chairman. At the outset, we will defer item number 2 on the administrative agenda to next week, January 20, 2021. There's one item on today's consent agenda. It is a notice from Radiate Holdings LP, Star Power Communications LLC, DBA, RCN, and Stone Peak Associates for LLC of acquisition of an indirect ownership in a Maryland telecommunications company.
Thank you. Are there any questions on item number 1? Seeing none, I move that we note the acquisition of Stone Peak Associates 4 LLC of indirect ownership of Star Power Communications LLC, doing business as RCN. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved. Mr. Secretary, the administrative agenda, please.
Mr. Chairman, item number 3 on today's administrative agenda is a demand charge credit compliance filing from Baltimore Gas and Electric Company for public direct current fast chargers. On this item for staff, we have David Hoppick, Annette Garofalo, and Drew McCullough. For the company, Bev Sakura, Lynn Fiery, and John Frayne. For Peoples Counsel, Fred Hoover, and also David Beelgemans and Charlene Dumit.
Thank you. Good morning, Mr. Hoppick.
Good morning, Chairman and Commissioners. David Hoppick on behalf of staff. On December 4th, 2020, Baltimore Gas and Electric Company, or BGE, filed revisions to its Rider 5 electric vehicle charging distribution demand credit to comply with the Commission's November 18th, 2020 letter order. The proposed revisions expand the distribution demand charge credit to public DC fast chargers installed between July 1st, 2020 and December 31st, 2021 for up to 166 chargers in BGE service territory. Sets the maximum demand charge credit based on 50% of the maximum aggregated demand of the charging site on a going forward basis, and makes the credit available until December 31st, 2023, or until the Commission approves commercial electric vehicle charger rates. Staff recommends that the Commission accept the tariff revisions for filing with an effective date of January 13th, 2021, and direct BGE to file clean copies of its tariff. Thank you.
Thank you. Before I turn to utility, are there any parties that wish to speak on this item? Seeing none, I'll turn to Baltimore Gas and Electric Company.
Good morning, Mr. Chairman, Commissioners. Daniel Herson for Baltimore Gas and Electric Company, and Happy New Year to everybody. I have with me today John Frayne and Lynn Fiery from our rates group, and Christy Fleischman-Gronke from our EV Smart group. My only comment is I want to thank staff for their analysis. I did notice they are recommending a clean filing of tariff pages with an effective date of January 13th, which is today. I don't really know if that's necessary. Nothing changed in the tariff sheets themselves. The Commission approved this program for expansion on November 18th, 2020. That was the day we proposed that the tariff sheets become effective. The program started on December 1st, 2020, so it might be a little confusing to have a January 13th effective date when the program actually started earlier. So our suggestion was going to be to keep the effective date November 18th, but obviously we'll do whatever the Commission directs us to do. So those are my only comments. Thank you.
Thank you, Mr. Herson, and Happy New Year. Mr. Hoppick, Mr. Herson raises a good point. We did approve these at the November 18th administrative meeting. Is there any need for an effective date of today when the program is in effect already?
Staff would not be opposed to an earlier effective date, so that would be, we're not opposed to that. I think that's acceptable.
Thank you. So that effective date should be November 18th of 2020?
I think that would work as well, yes.
Mr. Herson, is that the right date?
Yes, that's the day we had originally proposed, yes.
Okay, great. Thank you. And Mr. Hoppick, if you could go on mute, we're having some issues with your microphone there. Thank you. I appreciate that the parties have worked together, including Mr. Bugelman's and his clients as well. As I noted back in November, I think it's important, particularly for DC fast chargers at this early stage as they mature, to have some ability to recoup some of the costs associated with demand charges, which could be very substantial, even more substantial for level 3 chargers over level 2 chargers. It was interesting, however, I took a look at the number of fast DC chargers in Maryland within the 495 DC Beltway this morning, and there were 4 CHAdeMO chargers, 3 of the 4 in Tacoma Park, surprisingly. Whereas in the Baltimore Beltway within 695, we have 22 DC fast chargers. So 2 major metropolitan areas in Maryland of approximately the same size in terms of population, yet we have 22 DC CHAdeMO chargers in one jurisdiction and only 4 in another. Hopefully in the coming year, we'll see 2021 as the year of the EVs, and we'll see more equitable distribution of these fast chargers. And I suspect that these demand charge credits will help allow us to proliferate the development and installation of them. I don't have any questions for staff. Thank you. Any questions or comments from the commissioners? Seeing none, I would propose that we accept the tariff provisions for filing becoming effective on November 18th, 2020. And just as a note, the utility is not required to file revised clean tariff pages. The vote begins with Commissioner Herman.
I vote aye, and I will note that there are, I believe, two new chargers in my giant parking lot here in Pasadena, Maryland. So I'm not sure whose they are, but they're there. So that's good news.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye, and I will also note, Mr. Chairman, even thriving downtown metropolis Lusby has 2 new chargers in its giant parking lot.
And I would note that Lusby has been a leader. I think the ones at the Walgreens parking lot have been there for a couple of years now. Commissioner O'Donnell votes aye. Commissioner Richard.
Aye.
I vote aye. The motion is approved. Thank you.
Thank you.
Mr. Chairman, item number 4 is another demand charge credit compliance filing from Potomac Electric Power Company and Delmarva Power and Light Company for public direct current fast chargers. On this item for staff, again, David Hoppick, Drew McAuliffe, and Annette Garofalo. For the company, Matt Bonikowski and Doug McKeel. And for Office of Peoples Counsel, Fred Hoover.
Good morning again. Again, David Hoppick on behalf of staff. On December 4th, 2020, the PHI companies, Pepco and Delmarva, filed revisions to electric vehicle charging distribution demand charge credit rider to comply with the Commission's November 18th, 2020 letter order. The proposed revisions expand the distribution demand charge credit to DC fast chargers installed between July 1st, 2020 and December 31st, 2021 for up to 80 chargers in Pepco's service territory and 54 in Delmarva's service territory. Set the maximum demand charge credit based on 50% of the maximum aggregated demand of the charging site on a going forward basis, and make the credit available until December 31st, 2023, or until the Commission approves commercial EV charger rates. Staff recommends the Commission accept the tariffs tariff revisions for filing with an effective date as listed in the company's filing. Thank you.
Thank you, Mr. Hoppick. We'll see if we have a similar issue to the preceding case. I'll recognize the company, PHI.
Thank you, Mr. Chairman and Commissioners. We would also ask the same treatment that the Baltimore Gas and Electric tariffs got. Our tariffs that we filed are for usage on and after November 18th, 2020, which is the date that the Commission approved this. And we would also ask that we be allowed not to have to file new clean tariffs because these tariffs say that.
Mr. Hoppick, any objection to PHI's request?
No objection.
Thank you. I have no additional comments. I'm inclined to grant that request. Do commissioners have questions? Commissioner Linton.
Thank you, Mr. Chairman. Just one question for the staff. In your comments, you note that the distribution demand charge credit is available until the Commission approves a new EV charger rate or December 31st of 2023. Can you have any update on where we are with the discussions regarding a new tariff rate, or are we just, or should we look at this rate as being the one that will be in place until December of 2023?
I'll defer to Mr. McAuliffe on that one.
Hi, good morning, Commissioner Linton, Drew McAuliffe on behalf of staff. I don't believe we've had a EV working group meeting since the 18th. We may have had one. I believe we have one scheduled for the end of this month. But I wouldn't foresee a new rate, within the next few months at the earliest. So I would foresee these being the rates going forward for quite a while.
Thank you, Mr. Chair.
Thank you. Seeing no additional questions, I would move that we accept the tariff revisions for filing with an effective date of November 18th, 2020. Again, similar to the treatment of the prior item, the utility is not required to file clean copies of its tariff pages. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item number 5 on today's administrative agenda consists of updated 2021 stride surcharge calculations from Baltimore Gas and Electric Company to comply with order number 89678. On this item for staff, we have Drew McAuliffe, Afton Howard, Mark Riley, and Jamie Smith. For the company, John Frayne, Lynn Fiery, Dan Herson, and for Office of Peoples Counsel, Anna Ryan.
Thank you. Good morning, Mr. McAuliffe.
Good morning, Mr. Chairman and Commissioners. Drew McAuliffe on behalf of staff. On December 28th, 2020, Baltimore Gas and Electric Company filed its revised 2021 Strategic Infrastructure Development and Enhancement, or STRIDE, surcharge calculations to comply with the Commission Order Number 89678, issued December 16th, 2020, in Case 9645. The Commission previously accepted BGE's 2021 list at the December 2nd, 2020 administrative meeting. This filing was made to update the previously filed 2021 STRIDE surcharges to accommodate the lower rate of return that was approved in Case 9645 and approved in Order Number 89678. The revised surcharges are lower than previously filed 2021 STRIDE surcharges for all classes except for Schedule C. Staff recommends that the Commission approve BGE's 2021 STRIDE surcharges for filing effective January 1st, 2021. Thank you.
Thank you. We'll turn to the utility, Ms. Sakura.
Good morning, Commissioners. Beverly Sakura on behalf of BGE. We have no additional comments on this item.
Thank you. Do commissioners have questions on this STRIDE-related item? Seeing none, I would move that we approve the company's 2021 STRIDE surcharges for filing effective January 1st, 2021, with the vote beginning with Commissioner Herman.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item number 6 consists of revised electric and gas tariff pages in compliance with order number 89678 for Baltimore Gas and Electric Company in case number 9645. On this item for staff, we have David Hoppick, Anna Joy Thompson, Afton Hauer, and Jamie Smith, as well as Annette Garofalo. For the company of Sakura, John Frayne and Lynn Fiery. For Amtrak, Bob Weishart. And that is it.
Thank you. We'll begin with staff.
Good morning again, Chairman and Commissioners. David Hoppick on behalf of staff. On December 28th, 2020, BGE filed its revised electric and gas distribution tariffs to comply with order number 89678 in case 9645. These tariff revisions implement the revenue requirements of the Commission set for electric and gas distribution service in 2021, 2022, and 2023 in Order 89678. Additionally, these filings include base distribution offset riders 34 for electric and 18 for gas to offset 100% of changes in distribution charges from 2020 to 2021, net of changes from Rider 25 and Rider 8 bill stabilization or BSA adjustments. There is no bill impact to customers in 2021 resulting from this filing. As staff notes in its filing, there are two issues for which interpretation of Order 89678 may be required. The offset to the decrease in 2021 Schedule T volumetric distribution rates, and 2, proposed increases in 2021 distribution interruption penalty prices for gas schedules IS, ISS, and EG. Regarding the Schedule T 2021 offset, staff proposes to accept BGE's offset to Schedule T as it conforms to the requirement of paragraph 429 of Order 89678 that no charge in 2021 should be different than it was in 2020, but notes that if the Commission were to decide that no offset should be applied to Schedule T rates, that BGE should ultimately be made whole. For BGE's proposed increase in 2021 distribution interruption penalty prices, staff proposes to keep these prices unchanged in 2021 per paragraph 429. Staff recommends the Commission accept the tariff revisions as revised by staff in its comments dated January 4th, 2021, and direct the company to file clean copies of its tariff with an effective date of January 1st, 2021, and direct the company to provide the Commission updates on implementation of the offset rider as a line item in customer bills as more information becomes available, and display Schedule SL offset rates on the company's website. Thank you.
Thank you, Mr. Hoppick. Thank you to staff and thank you to the parties for reviewing the order timely and preparing these bulk sheets and the related pleadings on a tight turnaround basis. We'll next turn to Mr. Weishart on behalf of Amtrak.
Yes, good morning. Thank you, Mr. Chairman. Good morning, Commissioners. Amtrak filed comments on Monday, January 11th that addresses the Schedule T interpretation issue. Our read of the Commission's December 16th order and reading paragraph 429 in context with paragraphs 424 through 428 indicates that the no change language that's in paragraph 429 was driven by concerns about the financial impact on customers as a consequence of COVID-19 and the Commission's objective of ensuring that no rate increase would occur for customers in 2021. That general directive of no charge should be different for 2021 than it is for 2020 also needs to be read in context with paragraph 462 of the Commission's order, which had a very specific directive about decreasing the distribution revenue requirement by $200,000 for Schedule T. So our view, Amtrak's view, is that the fairest interpretation of the language in 429 is that there should not be a reduction on one hand for Schedule T and then a corresponding increase by virtue of Rider Electric 34 in order to offset that. And in fact, the Rider 34 charge for Schedule T should be 0, so as to preserve the Commission's directive in paragraph 462.
Thank you. Are there any additional parties that wish to speak before I turn to the utility? Ms. Sakura.
Good morning again, Commissioners. Mr. Weishart spoke of fairness, but his proposal is actually unfair to BGE because by keeping or not accepting the offset charge that BGE has proposed for Schedule T, BGE would actually earn $200,000 less than what the Commission awarded to BGE for 2021. And, I don't know if the Commission needs me to walk through this or if it kind of is self-evident, but if we're giving, credits or we're decreasing Schedule T by 200,000, that 200,000 needs to come from other customer classes to get us to the level of the increase awarded in 2021. If we then have to offset that increased charge or that increased amount to keep all the other customers whole, again, to keep BGE whole, we have to charge Schedule T to get us back to 0. So again, Mr. Weishart is focusing on language that, talks about the revenues and, but again, the Commission said the revenue should not change. And that's exactly what the rate should not be changing. And that's exactly what BGE's proposal does. Schedule T's rates will stay the same in 2021 as they were in 2022 or in 2020, but in 2022, they will decrease by $200,000.
Thank you, Ms. Sakura. I recognize that we need to harmonize paragraph 429 and paragraphs 462. I believe it was the Commission's intent in paragraph 462 to provide Amtrak with an immediate rate reduction. I recognize paragraph 429 makes a few exemptions, but does not capture what we stated in 462. Ms. Sakura, a moment ago, you heard from Mr. Hoppick stating that BGE should be made whole. I agree with that position as well. What is the issue with not simply reallocating the $200,000 to other rate classes? It was evident in the Commission's order that we saw that this one customer class, the Schedule T customers, were over-earning, and in an attempt to move everybody closer to 1, that was the first step that we took with respect to Schedule T. So that $200,000 would effectively be shifted on some type of a proportional basis to other rate classes. Can you answer that for me?
We could certainly, that would be an option. I guess, as we're reading the order, we didn't think that we had the leeway to do that ourselves, to take that $200,000 and allocate it to other customer classes. What we could do is, just when we get to the reconciliation process, we could propose, doing that in that instance and, just letting it run through the reconciliation process so that we don't have to change rates at this time.
I'd like to hear from the other commissioners on that point. But Mr. Weishart, what is your response to what Ms. Sakura just proposed?
Yeah, if I understood what Ms. Sakura was proposing is that the Rider 34 charge for Schedule T would be reduced to zero. The $200,000, which she claims is a shortfall, but the $200,000 would be reconciled at a later point. If that's the proposal, that's certainly acceptable to Amtrak. I mean, the mechanics of how BGE is kept whole, consistent with staff's position that they should be kept whole. Amtrak doesn't have a strong view on that.
I'm sorry, Ms. Weishart, you don't have a strong view on whether BGE should be kept whole?
Amtrak has no objection to BGE being kept whole. The mechanics of how BGE is kept whole, we don't have a position on that.
Understood. Thank you. In rereading the relevant sections of the order, and as I understand the proposal that Ms. Sakura just made to handle this through the reconciliation process, it would seem that Amtrak would be indifferent as to how this rate reduction occurs. I would inquire of my colleagues if they have any questions on this point or other points in the compliance file. Seeing.
Your Honor,
Yes.
I apologize. I was responding to Amtrak, but I also did want to talk to staff's proposal about the gas penalties.
Thank you. Let me inquire with Commissioner Herman first if she has a question on this particular item before we move on to your next item.
And actually, I was going to ask about the gas penalties and BGE's response, so I'll let Ms. Sakura proceed.
I read your mind. So the gas penalties are really a mathematical function of our other gas distribution rates. As you know, interruptible customers pay significantly less for their service because they're expected to interrupt. But what the penalties do, the mathematical calculation, so to speak, is, make it so that if they don't interrupt, they end up paying more than what a firm service customer would have paid. But what happened is in our last case 9610, the parties agreed that even though the penalty rate should have gone up because of the mathematical manipulation of the other rates that had been agreed to, that we would keep them at the same level that they had been at previously. So BGE, staff is correct that BGE is proposing to increase the gas penalties from 2020 to 2021, but it's not because we're not applying the offset. The increase is because there's no longer an agreement to hold them at artificially low levels. And I can kind of run through hopefully a simplistic example of this. So, assume in 2019 the penalty was $1 per therm. In 9610, the penalty should have been increased to say $2 per therm based on this formula. But again, the parties in the settlement agreed to keep it at $1 in 2020. So now we get to this case and the penalty is increasing to $3 in 2021 based on the formula. But then again, you add the offset and it only increases to $2. So there is an increase from $1 in 2020 to $2 in 2021, but it's not because of us not applying the offset. It's because the penalty had been artificially low because of the agreement in the settlement agreement. The penalty in my simplistic example should be $3, but it's only going to be $2 because we've applied the offset, but it's still increasing because the $1 that it was last year was artificially low. If that made sense.
So thank you, Ms. Sakura. That makes sense to me. And I have to ask staff, why does staff think that this is a charge? I have a hard time if staff's position is we shouldn't increase this because it's a charge and charges aren't supposed to go up. To me, I have a hard time understanding how this is a charge.
So, Commissioner Herman, we did, in our comments, attempt to express that we were hedging a little bit on this issue. So we did wrestle with that, obviously ourselves. So we did look to for example, Comar. It does not have a definition of charge. There is a definition of rate in the public utilities article. And so, there wasn't something hard and fast we saw to say it is a charge or not a charge. One thing we did do was look at the tariff itself. And if you look at the interruptible classes, the prices for example, delivery are listed as a delivery price, a demand price, and they're on a dollar per therm basis. And then the distribution interruption penalty price is also listed as a price on a dollar per therm basis. So kind of part of our thinking on this is that the customer, for them interpreting, the order that's saying no charges should change and then seeing one of these charges has changed, there might be some confusion there. And then, we also, we're trying to be a bit cautious and reflecting paragraph 429 and the Commission's apparent intent that charges would not change. So hopefully that helps you understand that.
Thank you. I appreciate it. And I did see the comments and I saw that you struggled with it, as do I. And in my view, I think that we should keep BGE's penalty, distribution penalty for interruptible service. I think it's appropriate to leave it as BGE proposed. With respect to, Mr. Chairman, the Schedule T, I agree with you, Mr. Chairman. I think that we did intend for Amtrak to have that reduction, and that the $200,000 we can determine the best way to proceed with respect to that on a future date. And I do have some other questions with respect to Rider 15, but I'll hold off and let my colleagues weigh in on these other two issues first.
I also agree. I'm sorry. Was it?
Commissioner, yes, please proceed.
Oh, thank you, Mr. Chairman. I also agree with the chairman with regard to Schedule T. I believe that was our intention, to allow the reduction to go into effect immediately. And I also agree that the rate should remain, the penalty should remain as proposed by BGE for the interruptible customer.
Yeah, I also agree. We certainly intended to provide the Schedule T with immediate relief, and we didn't want to give with one hand and take from the other. So, and then on the other, I do agree also that the tariff should remain for the interruptible service.
Agreed. Our intention was clear. We want immediate relief for Schedule T, and I think we should keep the penalty as proposed by BGE. So I think we have 100% consensus here.
Thank you, commissioners. Any additional questions or comments on this item?
Yes, Mr. Chairman.
Commissioner Herman.
Ms. Sakura, I'm looking at Rider 15. I'm looking at the filing that's, at least on my PDF, the PDF that's labeled Supplement 472 Tariff Pages, page 21 of 44.
Okay, let me get there. Okay, I believe I'm at the same page you're at.
Okay,
oh,
it's the red line on Rider 15. Okay. The third paragraph there. The second sentence, first of all, I think there's a typo, which I think you can fix. I believe that recollection should be reconciliation.
Oh, yep.
Yeah.
We missed that one.
But, you know, I really stumbled over that second sentence because it says that the final reconciliation shall cover investments and costs in the MRP period not previously reviewed for prudency and reconciled in the rate case. I believe that we all today, having just gone through this rate case, understand that the commission has not approved for prudency any of the projects that were included in the multi-year plan. You agree to that?
Right, yeah.
Right. But I'm a little bit concerned that this sentence could be read by people in the future to believe that, in fact, when you say investments and costs the MRP period not previously reviewed for prudency and reconciled in the rate case, it kind of sounds to me like somebody could read that to say that the rates that were approved in the multi-year plan included a prudency review. Do you follow what I'm saying there?
You're right, Commissioner. And you know, reading this now again, I can see that it could be confusing or be misconstrued. I think what, and there may be language missing. If you recall, in the order back from last February, there's kind of two bites or two parts to the reconciliation. We have to do, you know, we have to file a rate case 210 days before the end of the MYP, and in that rate case, we have to do kind of a reconciliation for really what is the first, I think the first 2 years of the MYP.
Right.
So we'll do that, and then after the MYP is over and the rate case is over, we have to submit information on kind of the reconciliation for everything that wasn't covered in the rate case. And that's really what that sentence is trying to say. Not very well, but it's really to say, hey, to the extent that there were, you know, the things that weren't addressed in the rate case need to get addressed in this separate filing. So I think that's what we're trying to address. Again, I agree, it's probably not, it's not worded very well, but that's what we are trying to address.
Right. And I accept that. I believe that. And, you know, my concern is that if this is language that stays in effect for 5 years or 10 years, for example, somebody who's not here today, who's just been through this whole thing and is very familiar with the order in the multi-year rate plan, it could be potentially misconstrued. So I made a stab at it, and I'll read it for everybody to think about, and you can tell me if you think I caught it. I would like to hear comments on this proposal, which is the final reconciliation shall include for review investments and costs in the current MRP period, not previously reviewed for prudency in the subsequent rate case. I'll read it again, and you can, you know, you can write it down and take a look at it if you like. You ready?
Yes.
The final reconciliation shall include for review investments and costs in the current MRP period, not previously reviewed for prudency in the subsequent rate case.
I'm pausing on the current MRP period because in the current, we could already be in a second
You're right.
MRP.
Mm-hmm. Well, I mean, perhaps we could. Let me ask you this. Do we have to have that sentence? Maybe the answer to that is just to take it out.
That seems reasonable to me. I'll turn to Mr. Frayne and Ms. Fiery for their thoughts.
Good morning, Commissioners. John Frayne. I think I would agree with that the sentence isn't necessary. Clearly, there are already PSE orders that, sort of would require and, allow us to go through that process, define it. It doesn't necessarily, I don't believe, need to get defined differently at all in the tariff. So I would agree. I think we could just strike that sentence and we'd be fine.
Thank you. I'd like to hear from my colleagues. Perhaps the answer is just simply, instead of having to worry about a subsequent interpretation, is just simply eliminating it, and the order would stand for itself as to what happens in the final reconciliation.
That would be my preference over something that is currently less than clear.
Yeah, and I was joking over the proposed new language, to be honest with you. So I'd prefer just excise the statement and it's clear.
Thank you.
So, Mr. Chairman, the same sentence is in Rider 16 for electric. So whatever we do for Rider 15, we should make sure is also done for Rider 16.
Yes, thank you, Mr. Hoppick. I was going to bring that up. I just happened to be reading Rider 15 first.
Thank you for catching that. Additional comments, questions, or thoughts on item number 6?
Your Honor, just in the spirit of full disclosure, BGE will submit revised tariff pages one will reflect that the offset charge to Schedule T has been eliminated. We'll remove this sentence from the riders 15 and 16. But also when we're looking at the offset rider as well, we discovered that a couple of the offset rates for Schedule SL just got transposed. And so we'll make that correction as well. And we'll make it clear what's kind of getting switched around. Again, it was just a transposition, so we'll fix that as well.
Thank you. I'll plan in a moment to make a global motion that will capture everything we've discussed today and give the utility an opportunity to make any additional cleanup edits when they submit both clean and redlined tariff pages. Is there anything further before I make a motion? I move that we accept the tariff revisions as being consistent with today's bench discussion and direct the company to file clean and redline copies of its tariff with an effective date of January 1st, 2021, and direct the company to provide the Commission updates on the implementation of the offset rider as a line item in customer bills as more information becomes available, and display Schedule SL offset rates on the company's website. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved. There's no further business on the agenda. However, I would like to note the arrival of our new Peoples Counsel. Mr. David Lapp has arrived and he's taken his position on January 1st of 2021. Mr. Lapp previously served for the past 16 years as an Assistant Attorney General working on Medicare, Medicaid, and various health issues. Prior to that, for about a decade, he served as a consumer advocate related to environmental and utility issues. So we welcome Mr. Lapp and his leadership to the Office of Peoples Counsel. Wish everybody a good day and rest of the week. With that, today's meeting is adjourned.
Thank you.